Hello, bonjour, Tanzi. I'm Kim from the Family Law Information Center. If you have separated from a spouse or partner, you may need to sort out how to divide family property, parenting arrangements, child support, and spousal support issues. Or you may be a parent and have a dispute with the child's other parent about parenting time or child support. There are many service providers who can help resolve family disputes. This video will look more closely at family mediators, collaborative lawyers, parenting coordinators, and family arbitrators. The goal of mediation is for parties to be able to identify their needs and brainstorm possible solutions to meet those needs. A family mediator helps parties move beyond their position to a deeper exploration of what their needs are. For example, in a dispute about parenting time, one party may come into mediation stating they want week on, week off parenting time. This is a position. The need underlying this position may be to have a strong bond with the child and to participate in a significant way in the child's life. Once the needs are developed and understood, the mediator can help parties look at potential solutions to meet those needs. There may be a few solutions that meet the needs of both parties and the children. At the first meeting with the parties, the family mediator will typically explain the rules, such as being respectful, asking for breaks when needed, and the process. Some parties bring their lawyers to mediation, but many parties don't. It is often just the parties and the mediator at mediation meetings. The first meeting is about understanding the process and understanding the dispute. It will usually take another 3 or 4 sessions to work through the dispute and identify the needs or interests and start developing solutions. With family mediation, the parties are in control. The mediator cannot force anyone to agree to anything. The parties themselves decide the terms of any agreement. Parties don't have to agree to anything they aren't comfortable with. Family mediators have at least 80 hours of training in mediation practice, family dynamics, and family law. They have also taken family violence training. Some mediators are lawyers as well as mediators. Mediators have a variety of backgrounds. Other mediators may not have mediation training specific to family mediation, but you can ask the mediator about their training and experience. As well as assisting parties to come to an most mediators also work with parties to improve communication between the parties, such as helping the parties reframe what they want to say to the other party in ways that don't sound critical or angry. Mediators may meet with a party separately to better understand what each party needs, and then work with the parties to talk to each other about their needs. Mediators are neutral. Their job is to work on the issue in the dispute, not to advocate for either side. Collaborative law is about both parties trying to work together to resolve family law issues. In collaborative law, each party hires their own collaborative lawyer. Most collaborative lawyers and clients sign agreements that they will work hard to resolve things out of court. The lawyers will talk to their client about his or her needs and possible solutions and provide legal information and advice. If a party decides he or she still wants to go to court, the agreement states that the lawyer will withdraw and the client will need to find a new lawyer. Both collaborative lawyers and the parties will then schedule meetings. Both parties and their lawyers attend the meetings. Similar to family mediation, the first meeting usually focuses on the process and what will happen at future meetings. The lawyers will likely identify what further information will be needed from each party and whether any professionals, such as an accountant, could assist. It usually takes a few meetings before the parties can come to an agreement on all or some of the issues. In between meetings, each party can ask his or her own collaborative lawyer for advice or assistance as needed. They may also suggest to parties that they work with other professionals, such as a financial planner or a parenting coach. The Collaborative Professionals of Saskatchewan includes members who are financial planners and parenting coaches who have been trained in the collaborative approach. If the parties come to an agreement about how to resolve the issue or issues, one of the lawyers will draft a written agreement and the other lawyer will review it. Both lawyers will make sure the agreement is signed properly and that everyone has a copy of the agreement. Similar to family mediators, collaborative lawyers have at least 21 hours of mediation training and have experience in working with families, as well as legal experience in family law. Collaborative lawyers also have received training about family violence. Parenting coordinators help parties communicate with one another and try to help parents agree on parenting issues. Parenting coordinators are trained to understand the needs of children, help each parent discuss their parenting-related concerns, and help parents manage and keep children out of conflicts. Parenting coordinators are often social workers or lawyers who have extensive experience working with families, and they work with parents to resolve disputes and help interpret or understand terms of their parenting agreement or court order. If an agreement isn't possible, the parenting coordinator can make a ruling. For example, if a court order states that the parties were to share summer work schedules and proposed vacation times with the children, and the parents both wanted the same weeks, the parenting coordinator would help the parents try to work out an agreement about which parent had the children which weeks in the summer. If they couldn't agree, the parenting coordinator would then decide who had the children for which weeks in the summer. Parenting coordinators work with the parties to create a process for resolving the dispute. For example, in order to resolve a dispute about parenting times or dates, the parenting coordinator may ask the parties to provide copies of their work schedule. If a child is seeing a counselor, the parenting coordinator may want to speak directly with the counselor. Parents hire a parenting coordinator for a set period of time, which is usually 2 years. This is set out in a written agreement between the parties and the parenting coordinator. The agreement also sets out how much each party pays for the parenting coordinator's time. A court may also order parents to use parenting coordination services. Even if the services are court-ordered, the parties still enter into a written agreement with the parenting coordinator. During the agreement, either party may contact the parenting coordinator for help in resolving a parenting issue. A family arbitrator can make binding decisions that are similar to court orders to resolve family issues out of court. The arbitrator is the decision maker, not the parties. A family arbitrator can determine what information the parties should provide, when the hearing might take place, how others, such as expert witnesses, new partners, or children, might participate, and the format of the hearing, such as an in-person hearing, or a hearing by video conference, or a hearing that proceeds by way of written evidence, affidavits, and written arguments. Family arbitration hearings are more informal than court trials, and hearings can be scheduled more quickly than trials. The parties may or may not hire lawyers to assist them. Arbitration hearings are private, and no member of the public are allowed to attend. The parties jointly pay for the arbitrator. When looking at your situation, you may want to think about these questions. What level of communication do you have with the other party? Do you have time and money to pay for someone to help you negotiate? Who do you want to make decisions? Saskatchewan's legislation has been amended to require people to try to resolve their family law disputes out of court before they can proceed with a court application. Depending on when you are watching this video, the requirement may be in effect in your area. You may want to go to the saskatchewan.ca website and search Early Dispute Resolution for more information. We will now look at how 3 couples made decisions about how to resolve their disputes based on their situation and needs. Fred and Wilma were married 15 years. They have 2 children aged 10 and 12. Fred and Wilma worked shifts to reduce the time their children would have to spend at daycare or with other caregivers. They have a house with a small mortgage. 2 cars, and an RESP. Fred is currently staying with his friend Barney, and Wilma and the kids are in the family home. Although they both feel angry, they have been able to talk to each other since their separation. Both Fred and Wilma would like to resolve issues without going to court if possible. Fred and Wilma both want to resolve issues as soon as possible, avoid conflict and fighting in front of the kids, ensure that parenting arrangements fit their needs and can be updated when needed, as well as keep their costs down. Fred and Wilma also consider the fact that they don't have a lot of family property to divide, that they would like to benefit from learning better communication skills, and that they will likely only need legal advice once or twice rather than on an ongoing basis. Fred and Wilma decide to try family mediation. Pat and Terry have lived common law for 10 years. During that time, they built a successful business. They separated after Terry discovered that Pat had been cheating, and Terry is very angry. They have not been communicating well and don't think they can manage the business together. Both of them want to keep the business, as neither of them has another source of income. Pat and Terry want decisions about the business made as soon as possible. Who will run the business? How will the value be divided? Will the spouse who doesn't keep the business get spousal support? No updating of the arrangement will be needed, as they have agreed it will be final. Pat and Terry are not able to communicate, but neither sees the need for communication in the future, as there are no children. Once the business and other property are divided and decisions are made about spousal support, they both intend to go their separate ways. Pat and Terry decide to hire a family arbitrator. Carla and Carl separated about 2 years ago. At that time, they wrote and signed an agreement setting out a parenting plan and child support. Things seemed to go well the first year. Carl had a new relationship with Anne, and Carl and Carla started having fights over parenting time. Now it seems they fight all the time. The kids seem to be more stressed, as Carl and Carla regularly get calls from the school now about their children's behavior. Carla has decided she wants to apply for a divorce and is thinking about applying for a court order for parenting arrangements and support. She tells Carl about her intentions. Carl and Carla agree that they used to be able to talk about the kids without fighting, and they agree they are concerned about their conflict affecting the kids. Carla has heard that going to court often makes the conflict worse. They also want clarity about the parenting arrangements and flexibility, as the kids are in different activities each year and want time with their friends on weekends. Carl and Carla have been looking for a service provider who can help them. They have found information about parenting coordination and collaborative law. They like that a parenting coordinator could help them better understand their children's needs and help reduce their conflict. They both hope that they can return at some point to being able to discuss their children's needs and parenting issues directly with each other. They like that the parenting coordinator can help them develop better communication strategies. Carl and Carla are also interested in collaborative law. They like the idea of having lawyers there to provide legal advice and guidance, and are committed to working with them to resolve their problems. Carl and Carla would prefer to resolve issues without increasing their conflict, and they like the fact that they and their collaborative lawyers agree in writing they will work hard to come to an agreement and they will not go to court. If they come to an agreement, the collaborative lawyers could write the new agreements up. Agreements are easier than court orders to update as the children's needs and interests change. Both options are attractive to Carla and Carl. Information about family mediation, family arbitration, and parenting coordination, including the names of service providers, is available at saskatchewan.ca by searching Early Dispute Resolution. Information about collaborative law is available at collabsask.com. It may also be useful to watch some or all of the other videos in this series, such as ending spousal relationships, parenting arrangements, child support, spousal support, finances during separation, and dividing family property. More information about family law is available online at familylaw.plea.org and at Justice Canada by searching justice.gc.ca. You can also phone the Family Law Information Centre toll-free at 1-888-218-2822.